In recent years, encryption software, particularly in the context of messaging applications like WhatsApp and Telegram, has been on the increase. As a result, when mobile phones are legitimately seized by the police, one of the first steps in the investigation is an attempt to scramble that encryption to access the messages and find out if suspects have any involvement in criminal offences. Now, those preparatory steps are entirely legitimate where, for example, the phone has been lawfully seized and the phone is in the possession of the police. But what happens if the phone is not in the possession of the police, or the very source of the phone, the very manufacturer of the phone, is him or herself also the subject of criminal investigation? I am, of course, talking about Encro phones. Now, according to the police, Encro phones have been used exclusively, allegedly, by organised criminal gangs, members of these gangs. Now, today I have with me Sav Khan, who is senior partner at Eldwick Law, who specialises in serious crime. Sav and I have conducted a number of cases together, and the most recent case involving encrypted software was a terrorist case. But of course, the software now is something completely different. Sav, can you tell us a little bit about the recent case, Encro phones, and why this video is now important?
Yes, the purpose, or I suppose what's prompted this video, is the recent case in Northern Ireland where it is alleged that the police or the National Crime Agency have been able to access a telephone belonging to a man who's now been charged with some serious allegations, including conspiracy to murder. And this is obviously then also prompted by the fact that Encro chat apparently sent a message last Saturday to their subscribers, to their users, saying that they could no longer guarantee that the chats which they were involved in are private, and advised their users, their subscribers, to dispose of those devices. These are extremely sophisticated devices, and they could be sold for as much as £3,500 on the market, and hence the reason it is alleged that a lot of organised criminals use these in order to hide what their activities are. But just because the police or the National Crime Agency or the authorities have managed to get into these devices and can see the content doesn't necessarily mean anything and everything on that device will be of a criminal nature. That then obviously brings us to the legality, how if the National Crime Agency or the authorities have managed to access these devices, how they've managed to do it, which part, if any, they're able to access, which part, if any, they're able to use or utilize in a criminal trial if a person gets charged. And those are obviously issues that will come to light in the near future as far as this case in Ireland is concerned, and possibly some other people who may up and down the country may well get picked up if these stories are correct, that the police or the authorities have managed to gain access into these phones. It would seem these stories are correct because according to the newspaper, this person who's been charged in Newry in Northern Ireland, his lawyers also given an interview, even though the NCA have not confirmed exactly how the evidence has come about. It would seem that the evidence as far as this man is concerned or his activities has resulted as a result of the fact that the police were able to access what's known as an Encro phone.
Well, Sav, thank you very much for that. And I think it's also worth mentioning that, yes, there no doubt are going to be cases where the police physically have the phone in their possession. But there will also be those cases where the police don't have the phone in their possession, but have the data that they say is attributed to a particular handle of a phone user. And questions will then arise as to where that data comes from, and whether that data is reliable, and whether that data has integrity. Moving forward, let's assume somebody is unfortunately charged with an offence based primarily on evidence from an Encro phone, either because the police have it in their possession or because the police have data in their possession that they say is attributed to the suspect. What are going to be the preliminary stages as far as any case preparation is concerned?
Obviously, our role, ordinarily speaking, is before counsel, before our barristers, because ordinarily speaking, when a person gets arrested or if they're invited for an interview on a voluntary basis, that takes place at a police station. That's where we as solicitors are involved. We will analyse the evidence against the person. We should be given some disclosure by the police, by the NCA, whoever is prosecuting the matter, as to why the person is in custody. At that stage, we will analyse that. We won't know exactly whether they've got the relevant authorities in order to be able to firstly access a person's phone, or maybe a situation where they've listened to a person's conversation. All those things are something which we'll have to deal with if a person is charged later. But certainly as far as the police station is concerned, we will analyse that evidence. We will then discuss that case with the person in custody, advise them, and they have a right at that stage whether they can or should not answer questions. We will deal with that. If a person is charged, then later on down the road, we will instruct telecommunication experts. Those experts, along with ourselves and barristers involved, will look at a number of issues. And they will also look, for example, as an example only, whether the conversations are attributable to the person who they're saying they're attributable to, where the conversations are taking place. For example, it may be about cell site analysis. There is something else which is quite topical nowadays, which is co-location, where a person or persons may have more than one device on them, and the police, through whatever means, are able to prove that one of those devices belongs to the person, and what they then say is that the other device is moving along with this device. Therefore, we would like the court or the jury to draw the inference that the other device must belong to this person. An expert will look at a number of issues, and no doubt this is one of the things which the lawyers for this gentleman in Northern Ireland will now be busy instructing. Firstly, as far as the legality is concerned. Secondly, as far as the technical aspect of this device, or if there is no device, the material that's been gleaned from that device, what its legal and technical issues are. Tanveer, can you now just explain to us what happens once a person is charged, and once they've appeared in magistrates court, then the case goes to Crown Court? What happens at that stage, primarily as far as the legal side of things are concerned?
If and when this matter progresses to the Crown Court, it's important to emphasise we are still at a very early stage in the proceedings, far away from any trial. And I say any because a number of opportunities still exist to undermine the prosecution case, all the way to applying to dismiss the prosecution case if the evidence, for example, is insufficient. Now, the expert evidence that the defence will propose to rely on will only go so far. It will evaluate the quality of the prosecution evidence. But there are also other important points on which the defence can challenge the phone evidence. Attribution, for example. So in the case of Encro phones, obviously a mass message has been communicated to users, inviting users to dispose of phones. That in itself, of course, isn't going to get rid of messages, because the police may and are likely to still have access to the server on which these messages are contained. And there, where a prosecution case is built upon the server, real questions, genuine questions about reliability, about attribution, about the integrity of the analysis will then begin to be raised. And that together, a combination of all, can lead to an application to either dismiss or exclude the evidence.
Thanks, Tanveer. The most important part in a criminal trial, in my opinion, is the police station. That's the foundation upon which a case is built, or sometimes where a case falls. It's absolutely essential, in my opinion, that if a person is about to be spoken to, or if a person is to be arrested or is under arrest, that you have the appropriate legal advice. It's also obviously essential that if those people that have already been spoken to are now on bail or released under investigation, then you can contact lawyers like ourselves, myself and Tanveer. Then we can then prepare a strategy, because a criminal case takes a lot of thinking through. Your tactics have to be right. It's not always the strength of the evidence upon which people are convicted, but sometimes the tactics which a defense run are also extremely important. So it is absolutely essential that those tactics are formulated at an early stage and they're also put into action at an early stage. So if there is a need for the police to speak to anybody, it's absolutely essential that you have the appropriate legal advice. And obviously myself at Eldwick Law and Tanveer are available, and please don't hesitate to contact us in that scenario.